Thank you for joining me on my YouTube channel. My name is Christiana Sage. On this channel, I will be teaching about international law, and these teachings will be in the form of short weekly lecture series. Over time, I will be surfacing varied concepts of international law. When and where applicable, these concepts will be analyzed and brought to you as it relates to current trends in international law as they arise. At the end of this lecture, you will find the transcript of the lecture in the link below. Also, for current trend and analysis in international law, you can subscribe to my blog. All the details you will find in the comment section below. For the 13th lecture in this lecture series, we will be addressing the concept of recognition. In our previous lesson on statehood, we spoke of recognition as either constitutive or declaratory of a political entity's statehood. In lesson 11 on secession, we made reference to the concept of recognition as potentially vesting legitimacy on a seceding entity. For this lecture, we will pick up on the previous lessons had and interrogate in a little more depth the concept of recognition. To this end, we will look at the background of recognition, types of recognition, and the impact of recognition. Background. In its basic form, recognition is a formal declarative political act of one state that another political entity exists as a separate and independent state. To cast light on the concept of recognition under international law, perhaps it will be helpful to look at why it emanated in the first place. So let's take a dive in. Recognition is said to flow or have its origin in European monarchy. In the early times of monarchy, it was not uncommon to see overlapping claims to succession. So recognition of any of the several contesting claims to succession generally gave legitimacy to the claim that was recognized. We can say, therefore, the recognition is a political act with legal consequences, and this holds true even to this day. Within contemporary international law, we see examples of bilateral and multilateral instruments that have encapsulated the basis upon which a political entity would receive or has received recognition. One of the earliest examples that we see regarding interstate relationships and recognition is that of the Spanish Crown's recognition of the United Netherlands in the Treaty of Peace between Spain and the Netherlands, also known as the Peace of Münster of 1648. In more recent times, we see the Declaration on the Guidelines on the Recognition of New States in Eastern Europe and in the Soviet Union of December 16, 1991, which was adopted under the auspices of the European Council. This is a formal guideline on the recognition of new states in Eastern Europe and the Soviet Union. Recognition, though a political act, is relevant for the distribution of legal obligations and in a broader context to determine the resolution of issues in dispute. It is imperative, however, to note that there is no such thing as a right to recognition, and as such, there is no corresponding duty or obligation on states to compulsorily recognize another state or government. To the forms of recognition. The question of recognition is relevant in the following contexts: states, governments, and belligerents. For this lesson, we will narrow down our focus to the recognition of states and governments. So, recognition of states. It is crucial to establish as a foothold fact that where there is no dispute regarding a claim to statehood, recognition becomes a matter of routine. The necessary implication will be that where there is a dispute about a claim to statehood, then a determination to recognize a political entity in question has real life consequences and creates legal obligations. Where recognition of a state is withheld, it could be for a number of reasons, including that the recognizing entity does not deem the recognition seeking state as having met the requirements for statehood. Quite often, this stems from a perceived lack of independence on the recognition seeking entity. For example, Northern Cyprus, which was established by Turkish intervention, as well as South Ossetia and Abkhazia, which are perceived by the international community as a derivative of Russian intervention, have been denied recognition by the international community for their perceived lack of independence. Since the formation of Northern Cyprus in 1983, it has received recognition as a sovereign state only by Turkey. The United Nations recognizes it only as a territory of the Republic of Cyprus under Turkish occupation. In essence, the UN does not recognize it as a sovereign nation. Since the secession of South Ossetia and Abkhazia from Georgia in 1992, they have received recognition from about 10 states only. Also, states are very reluctant to recognize an entity that developed out of aggression or gross violation of human rights norms or jus cogent norms of international law. This we also see encapsulated as a guideline in the Declaration on the Guidelines on the Recognition of New States in Eastern Europe and in the Soviet Union. Where recognition occurs, it can either be expressed or implied. An implied recognition is often referenced by the extent of relations a state or the United Nations has with the entity seeking recognition. What this means in practical terms may be blurry, but generally, the existence of full diplomatic relations evinces recognition. To the recognition of government. The question of recognition of government only arises with regards to already recognized states. As with recognition of states, where there is an effective government, that is, a government with unquestionable control, recognition becomes also a matter of routine. What constitutes unquestionable control can be gauged by the acquiescence of the people of the states seeking recognition and the willingness of the government in question to comply with international law. Often so, the many layers of complexities that accompany the question of whether the government is the jure and or de facto also come into play in determining if the government seeking recognition would in fact receive such recognition. Throughout this lecture series, we have established that interference in a sovereign state's internal affairs is prohibited under international law. And undoubtedly, issues of change of government are a matter of domestic concern, whether the change is constitutional or not. So the question is, when does the recognition of governments become an issue for the international community, and why does that even matter? To the when. This becomes a question for the international community where there has been a revolutionary change in government, or in the case of two or more competing claims to the government of a state. To the why. This becomes important because it has implications for international relations as a state or government has no status until it gains the recognition of the international community. And now we will address the impact of recognition. Having given a brief overview of what recognition is, to give a more practical illustration, we will look here at some of the impacts that recognition has for a state or government under international law. Concerning the United Nations, recognition has implications for determining if a state or government has authority to be represented at the United Nations, including if it can be admitted as a member of the United Nations. Recognition or lack thereof by the United Nations has implication for determining if the rules of the United Nations and public international law rules apply to a state or government and to what extent. Also, the ability or inability of a state or government to enter into diplomatic relations with other states, including treaty relations, are closely linked with whether the state or government has received recognition. Just to recap, in this lecture, we have attempted a brief definition of recognition, tracing it to the monarchy in Europe, and situating its application in contemporary international law. We have gone ahead to give some instances of what impact recognition or lack of recognition may have on entities seeking recognition. So we're pleased to let you know that we have exciting content lined up. First, in the coming weeks, we will be bringing a playlist that would encompass research resources for various topics in international law. I'm personally excited about this playlist and you should look out for it. Also, in the next 4 weeks, we will be addressing lessons on state responsibility, humanitarian intervention, neutrality, and diplomatic immunities. Remember to engage on here in the comment section, on Facebook, on Twitter, and let us know the content you'd like to see. So I want to say thank you so very much for joining in. Remember to like, share, subscribe, leave your comments in the comment section below, and hit the notification bell so that you're notified when there's a new video. Thank you.